Yes.
I beg to mention for listing lordship one bail application for tomorrow lordship. Press meter.
Bail mentioned. I'm taking a bail. Huh? So as per Ustar, I can mention can be made here. No? Okay. Yes.
Tomorrow lordship.
Motion.
Lordship.
BA.
BA.
Okay.
Much obliged.
Orders.
You wait for something. Yes, Majumdar, let him have some time.
My lord, only 2, 3 things I'll just point out, madam. Orders were for a particular officer to take a decision on my representation. He's he's the presiding officer of a court of inquiry. Ground given is, I am asking everybody what to do. Can that be the ground, number one? Number two, what he has done all through this.
Their ground is not extension. They want time to prepare to go to the upstairs.
The lordship will kindly.
Let them have the, isn't it? You are preparing to go to the upstairs. Therefore, you want some time.
No such
You will give
instruction
the
is given
extension.
to me.
Huh?
I have only that much instruction that I have stated in paragraph 8.
8, that all the respondents together.
You are having a benefit. Enjoy it. Otherwise, this is not your only concern. Was why should they go? Because they are just second. Let them, if they can do, because they are themselves are not clear from the record. What is this?
The only difficult.
Is that it? From the record itself, what is, in fact, it is under what provision of law?
They do
Why
not-
they have done nothing?
And
So we are giving, because we also cannot interfere.
had it been on the ground.
What she had argued is something different on record. Subsequently, when I have gone through it, each and every, that's why there was a delay in delivering the judgment.
And what they have done now is all my juniors have been promoted. Naming the court of inquiry, I am being kept in seal cover. Yesterday I saluted my juniors. Is what my
But we have
petition
specifically clarified that on the basis of this, you cannot be
is.
punished. As simple as that.
Naming the court of inquiry, they are keeping it in seal cover. Now I have to come back. That is the only difficulty. They are using everything they can to.
Yes, when can you do this?
They asked for 6 weeks further time. If lordship is counting it from today, then 6 weeks. If lordship is counting it from the date of filing,
Okay,
then
where you do whatever you like, we are issuing a notice to Mr. Mojumdar and
Okay.
fixing it. We are not passing any order today.
At least let them hurry up.
You have a file contempt,
No, I have not filed it.
not yet filed.
I have not filed.
Then you make a mention. We are just issuing hard MSB Sharma, learned counsel for the, you, in the meantime, you do. Since it is pending, contempt may also come here, we do not know. Sharma, learned counsel for a petition. The present application is filed seeking extension of 6 weeks more time for implementation of this court's order dated 15/3/2024. Full stop. Whereby, amongst other, the employer / applicant was directed to consider the representation preferred by the petitioner on 28/03/2023. Full stop. Issue notice returnable on give a date immediately after reopening. Okay, your time will be over.
Yes.
On date, either it will be infectious.
They will have come to a decision.
Yes, let's 23rd of July. 23rd of July, Mr. Mojumdar accepts notice on behalf of the respondent number 1
yes, one of the.
or sole respondent,
Sure.
sole opposite party. Full stop. Accordingly, no formal notice need be issued. Full stop. List this matter accordingly. We'll see. Okay.
My
Pendency of this
only the-
application shall not be a bar to consider the complete the exercise. Complete the exercise as directed by this court under its order dated.
15/3/20 or 15/3/24.
my objection that there is no explanation what was done in the time.
Full stop.
Only that observation.
উপৰত লিখিব Mr. Hard Mr. Sensor কলো ন তাৰপিছত লিখিব Mr. Mojumdar appearing on behalf of the sole opposite party contends that the present application is filed with a mala fide intention and only to delay the promotion of the petitioner in the name of the LS Court of Inquiry, LS Court of Inquiry, in as much as his consideration for promotion is kept on seal cover for the pendency of the pendency of the court of inquiry. Full stop. Issue notice, issue notice. In the meantime,
In the application,
Hmm.
no explanation
Okay.
what was done in
it
the
is
last.
further
instance.
contended by Mr. Mojumdar that no explanation, the explanation sought to be given for seeking time is not sufficient for this court to
Yes.
extend such time in as much as already sufficient times were
Yeah.
granted to the petition. Full stop. Issue notice returnable on so and so, so and so. In the meantime, Mr. Mojumdar may file an objection to the prayer made. Yes. Yes,
May I present your lordship?
Yes.
My lord, this matter has been extensively heard, my lord.
not exclusively, we are trying to understand.
My lord.
Yes.
My lord, my respected senior friend has argued, but I have been requested, my lord, to represent the petition. My lord, the case which has been
Before the
registered.
starting, my lord, may I just pray, my lord, can it be taken up on the presence of the Bhattapur, my lord?
Borthapur was
Yes,
there.
so he's facing some problem, my lord, because.
Oh, his
he-
father is
yes,
not keeping well.
Mother, my lord.
Mother is not. keeping-
Yes.
Okay,
He's
then
very
on
much-
that ground we'll adjourn.
Sought accommodation.
Last week of June, my lord.
Last week of June, give it date. Week commencing from
24th.
week commencing from 24th. Or we can take it 25th.
Yes.
25th?
My lord.
Okay.
I'm
It is
deeply
submitted that Mr. Borthakur is having, P. Borthakur, an additional public
On
prosecutor, is
legal
having
matter.
some personal difficulties. Accordingly, on his behalf, a prayer for adjournment is made. Prayer is allowed. Release this matter on 25th. We'll complete on that day.
Obliged.
No, then that, what is,
Then
you
we
just,
will just,
somebody who prepare it because
prepare. If it
she is also having an
because
urgency in
it
this.
is
matter.
within this time.
Okay. You also to
Yeah.
get
If
yourself prepared.
Obliged.
Wait, please, your lordship. Lordship, I mean, item number 3. And on last occasion, the argument in item number 2 was over, my lord.
I think just one thing I would want to make it clear, my lord, regarding my lord, lordship may kindly say section 32, that the power of, by the power of the court regarding my lord, the stay of the sentence, my lord. Clear in that section, my lord. Lordship.
নোট মনে হয়েছিল
32A, my lord.
LCR
32A, my lord, NDPS, my lord. That might have some bearing on your lordship's decision, my lord. That is why I just make.
Yes, 30
No, my lord,
section
no, my lord, section 32A.
section 32A.
Okay, my lord. And this section, notwithstanding anything contained in the Code of Criminal Procedure, any law for the time being in force, but subject to provision of section, no sentence awarded under this section shall be suspended. This section is somehow, my lord, somewhat diluted by one judgment, my lord. Let's say that, my lord,
Section 32,
section 32, my lord.
punishment for offense to
Yes. Yes, 32A, my lord.
32A.
That no sentence awarded under this act shall be suspended or remitted, my lord. That part, my lord.
Oh, that bar will, suppose there is a case
No,
of
my
no
lord.
evidence. We
Yes, no, my lord.
apparently we've seen that.
That is
Can
fine. No,
you-
my lord, what I want to submit, my lord, this section is somewhat diluted, my lord, by one judgment, my lord. It stated, my lord, that code, my lord, legislation, my lord, by legislative order cannot take away the power of the court to suspend.
Yes, yes, that is what.
Yes, that has been, and but the whole section is not made, my lord, unconstitutional. Only that part, but it is also held that the stay will be subject to satisfaction of section 37.
Of course,
That-
regular 37 will be
that
there.
is-
We'll see.
yes.
We'll see.
Yes, that is what I want to make clear.
Yes.
So there is no absolute bar, but as
Regarding 32, my lord, I'm facing this judgment.
Where is Mr. Bhattacharya? Okay, he's not.
he told that he will not be available.
Okay.
So here, you know, the constitutional validity of 32A was
No,
challenged.
that is,
But
that
that is
is,
what I
that is not.
explained, my lord.
That is, we know.
That is,
My lord, my
What is
the-
your
the-
case? What is your case?
The allegation is that on the basis of a specific information, 1.80 kg of ganja was seized from the house of Bunu Sargiari. That is the petitioner item number 2.
Mm.
And upon being led by him, 38.32 kg of ganja was seized from my house.
Mm.
That is the allegation.
Mm.
And to prove this, Your Honor, they have exhibited 2 seizure lists.
Mm.
One is exhibit P3 and one is exhibit P4.
Just a minute. Exhibit
P3, that is at page number 70 of the IMI.
exhibit P3
P3,
and
exhibit P4.
P4. Okay.
Exhibit P3,
Who are the seizure witnesses for in your case?
in my case, it is Mili Goyari,
No, okay, PW,
PW2,
PW2 and
Dwingsri, that is PW3,
PW3.
and Habasi Sorgiari, PW4.
Okay.
Now, these PW3 and PW4, they were also the seizure witnesses of the other
Yes.
this. If your lordship will come to page number 62, that is
Precisely what is your ground? Tell us precisely.
precisely, my lord, that none of these seizure witnesses,
Hmm.
they have said that they have seen seizure of ganja in their presence.
Hmm.
And out of these 3 witnesses, this Nili Goyari, she was declared hostile, my lord.
Okay.
And it was suggested
So
that
according to you, possession was, recovery was not proved. This is first ground.
First ground.
And second ground?
Second ground, apart from these seizure witnesses, there were PW1 and PW7, these were the official witnesses. That is Aminul Islam, who is the informant, and PW7, he is the investigating officer. Now, Your Honor, only these 2 witnesses have orally deposed that ganjas were seized from the house of this petitioner. But if we go through the evidence of PW1 and PW7, they negate the story of each other, Your Honor.
PW1 and PW7 contradiction.
Contradiction, because PW1 and PW7, they claims that they went together to the spot
Mm.
for search and seizure. Now, PW1,
Mm.
which is at page number 57 of the IA,
Mm.
he states that he, after getting the information,
Mm.
he went to the house of Bunu Swargiari at 4:10 AM.
Mm.
And the place of search was Bahadur Sa Adarsa Gaon.
Mm.
Now, PW7, who is the investigating officer, he also claims that he was along with the team, but he says that they went to the place of occurrence after receiving the information at 8:10 PM, almost a difference of 16 hours. And the place is also different, that is Huimanguri village. So Aminul Islam said that it was Bahadur Shah Adarsa Gaon.
Cross-examination on them.
My lord, these are stated in the chief only, my lord, 57, page number 57, it is PW1.
So these are your ground that place of recovery is doubtful from the prosecution itself.
Yes.
And second is that recovery of the contraband is not proved by the independent witnesses.
Yes.
So therefore
Other
entitled for bail. Yes.
And other grounds are also there, my lord.
Hmm.
Now, after, this is the seizure part. Now coming to the sampling part, Your Honor. This PW1, he has exhibited the FIR.
Hmm.
And in the FIR,
Sampling, okay.
FIR.
Who
he has
exhibited PW1?
PW1.
FIR, PW1.
PW1,
Hmm.
FIR as exhibit P6.
Hmm.
FIR is at 54, Your Honor.
Hmm.
In the FIR, he writes that from the seized suspected cannabis bags, 4 samples was made,
Hmm.
which was marked as A, B, C, and D,
Hmm.
observing all full formalities under NDPS Act.
Hmm.
So the samples were marked as A, B, C, and D.
Mm.
But if we see the FSL evidence of the FSL authority, that is PW6, it says that it is a page 80. Description of the article that was received by this FSL authority. 4 seal envelopes marked as S1 to S4 respectively, each having a closed polythene packet containing 25-gram dry plant materials. So admittedly, the materials which was, the samples which were drawn and which is marked as A, B, C, D, this report doesn't pertain to those samples because the markings are completely different. And regarding
Yes.
sampling, Your Honor, there is only one liner evidence by PW1 that I have drawn 12 numbers of samples. How they were packed, whether they were sealed or not, or what was
What
the.
is your cross-examination on that? Or any suggestion?
57. Let read the cross-examination.
Yes,
Okay.
regarding that procedural lab sealing, keeping it in the police station,
I
not
have
giving
mentioned,
anything? How many days? you have been-
Regarding this sampling,
When
there
this
is no
bandit-
cross-examination.
No, it was-
How many days?
How many days you are behind, but?
Your Honor, 2 years, 3 months,
What is that what was the conviction?
conviction 10 years.
Okay, we'll go through and record and pass on.
Earlier, my lord, that, okay, now is
Yes.
we are going for a bail application, my lord. Other things, my lord.
We'll pass orders. Yes.
Alright.
Yes, Mr. Bora.
Well.
What to do? Complete? You
Yes,
have your, your arguments almost complete.
Almost complete, only one point is there, and then the few judgment I want to place it.
Mm.
Probably Lordship will remember the whatever my first, probably there is a noting by your Lordship
Ah.
itself.
Mm.
My
40
first point of argument was regarding the chain of custody.
Mm.
That where from it is collected, where, and the sampling regarding the magistrate, there is a.
One is that it was there well aware it will be at, late in the night. That is 142, I think.
Yes,
42. Then
rest is the chain of custody.
chain of custody. This
Chain
two.
of, yes, it was recovered in one place,
Mm.
taken to one police station, then again
Mm.
from one police station to the FF
Mm.
magistrate, and the regarding the magistrate, though it is not on, it was not exhibited by the prosecution,
Mm.
but as per the magistrate order,
Mm.
there is some, they have made a sampling, but it does not sampling, and the report doesn't also tell it, doesn't match. So the absolutely the regarding the chain of custody is totally doubtful.
Mm.
That was the chain of custody.
Yes.
And there's a one more point regarding the sampling, my lord.
Mm.
There is a one judgment and there is a one notification.
Mm.
That what is the amount to be taken
Mm.
for sampling, my lord.
You are relying on one earlier on the mere presence of gazetted officer during search seizure will not mean compliance of section 42. That you are relying on that Sunil Kumar Roy and another Then similar. Then you are relying on Karnal Singh. Okay.
Yes. Gajraj Singh,
Sunil Kumar. Then
Karnal Singh.
Dadu Elias Tulsidas and Karnal Singh.
And there are other few judgment, my lord, I have given that list also. These are all, my lord, requirement of the 42. When it's a mandatory provision, here absolutely they are silent regarding that. Only received of the information, but the immediately, because it was admittedly
Yes.
done after the sunset and before the sunrise. So that,
Karnal Singh, you earlier also given paragraph 35, isn't it?
yes, paragraph 35, yes.
Yes.
And there are similar judgment, lordship can, then one is Rajasthan versus Gajraj Singh, that is paragraph 29. Then,
Jagras Singh,
yes,
State of Rajasthan, paragraph
Rajasthan.
29.
yes. Then the other was 2004, that is state of West Bengal, Babu Chakraborty.
That you have, already last occasion you have given.
Page 42.
Babu Chakraborty.
Yes. Then it, one more judgment, my lord, that is our High Court on the basis of a notification, my lord, that is paragraph 15, the sampling. The quantity required for the sampling. It is a mandatory provision, it's not been followed here also. The sort of the second part of the 42. That is mandatory, my lord, that's not been followed, admitted. That is the that provides you, my lord. Because there is no warrant of authorization, my lord, admittedly. And it is also conveyance. Ground of belief not been forwarded. To the immediate official superior. So here is a total non-compliance. In some judgment, lordship will find there is a partial.
That subsequently they can rectify it or
Yes, yes,
something. Yeah, but in your case, you say that
It
there
is
is
not
not
total,
a see nothing.
Yes, total number. That's all.
Okay. Yes, Goswami. Yes.
I have to, my lord, lead from the FIR, my lord. Page 56. my lord.
We are hearing the matter finally, isn't it, Mr. Bora?
Yes,
Lord,
Yes.
yes.
Okay.
Lord,
Page.
Page 56, my lord,
Hmm.
with the FIR, my lord. Dear lordship will find page 56, my lord. Here, the DD entry.
Hmm.
DD entry is there, my lord.
Hmm.
That has been exhibited, my lord.
No, FR, what you want to say? FR, please.
From the FIR, my lord, just that part.
General diary reference
Yes.
174.
17, my lord, another is, my lord. Regarding
One is 174.
one and another is 163, my lord.
Where do you
Yes.
get that?
That is, we'll find lordship, we'll find from page 57, my lord.
Page 56, 57.
7, my lord.
Yes.
It
General
is-
entry there
Yes,
is
my lord, this is lordship,
162.
yes, my lord.
What is the
This is
exhibit?
to page 57, my lord, I'm reading it, my lord.
Hmm.
This is to inform you that on 8/5, my lord.
Hmm.
8/5 information received at about 10:30 PM, that is at night, and information has been received by me from reliable source. A large quantity of drugs, heroin is transporting from Dimapur to Assam through NS started. Then immediately inform my deputy superintendent police headquarters Difu, and general diary entry was made by Delhi PSGD number
Hmm.
162/8522.
Now,
That is a
what is the
that-
exhibit of GD entry?
GD entry is 162. Exhibit, my lord, exhibit number is, my lord,
GD 163,
P31.
exhibit
P31.
P31.
P31
By PW41.
P31.
by
PW4.
PW4. Okay.
Now your lordship will find it, the authorized, he was authorized by the inspector, accordingly inspector, GD entry and
According Inspector
and
UB Swensu Brahma Bukazan.
self along with Raju Dwara and OC Khatkari PS SI UB Biplab Das of Bukazan and Elkenat Anang Boya.
Lordship also can find, take the my lord LCR also to
Mm.
see that particular GTN.
That you have shown us.
Yes, both are different, man.
Different. That is what, because
Yes,
one is
this is
162.
but what he is reading,
Mm.
that is not telling with the number.
That is
That is
the
the point,
difference. That we have
But-
seen.
I'll see.
Record.
Because
Maybe-
the exhibited 162,
Mm.
there is no, that is the GD entry, there is no authorization has been given.
I will see to that.
160, 162.
Let's get to GD entry 162.
Content is wrong.
Content-
GD entry 162.
Yes.
Is not it?
GD entry
8/5/2023.
Yes. It
It
is a
was
GD entry.
P3
ma'am.
within bracket 1 by
Yes.
PW4.
Yes,
Yes.
This is the GD entry, my lord. GD entry.
But it
But-
doesn't give the authorization. That is our
GD
case.
entry, my lord, does not give authorization, my
Ah.
lord, because GD
Now, where is
entry
the authorization
GD
exhibited?
authorization is.
But GD will require that
Yes.
I'll proceed, or this is my entry on the
Well,
basis of this.
Yes,
There is a-
authorization, my lord, what I,
According to the GT entry, এটা গোপন সূত্ৰে মোৰ পৰা স্বেঞ্চু এখন 4-চকীয়া বাহনত কোনো দুষ্কৃতিকাৰী কিছুমান নিচাজাতীয় ড্ৰাগছ হিৰোইন
Yes,
কঢ়িয়াই আনি আছে সংবাদ মাননীয় ডেপুটি এছপি কাৰ্বিলাৰ মহোদয়াক দিলে ফোন যোগে অৱগত কৰি মই SI লুৎফুৰ ৰহমান স্বেঞ্চু then they proceed.
Yes.
So
that part.
when they proceed, there is no authorization at that point.
may kindly.
Even it
my lord,
doesn't say about
no,
the, that they have taken the authorization in the
Lordship may
GD.
kindly see the FIR, my lord.
Mm.
Such and such came Bukazan were reported at PS and accordingly. And the second paragraph, as the information was received after sunset, likely operation of anti-search seizures would probably be before sunrise. So a written authorization was issued to me by MS Nahid Karisma. She is examined.
Where is that exhibit?
She is examined, my lord.
No, you have said that a
Yes.
written authorization. Where is that?
Written authorization, my lord. It is, my lord.
Where is that exhibit?
Hello.
See, the GD entry will
Yes.
not say, is not saying that you have got a written from Nahid.
Yes.
At the same time, there is no written authorization exhibited.
My lord, that my lord part will be cleared by my lord, the PW of my lord, Nahid, my lord.
What Nahid said.
What Nahid said, I will come to that.
So
my lord.
this
Yes,
will be the question.
yes, that will be the main question, my
Mm.
lord, because authorization officer is, she is on, not on, she
No,
only,
authorization can be later, at the later stage
Later.
also. It
Yes.
is an emergent
No.
prior.
My
Okay.
lord,
It's authorization before to the search.
No.
Stars marks. Yes, yes.
my
that
lord, there are two difference in text, my
Mm.
lord. Sometimes my lord, authorization was given, my lord, but the authorization of officer is not present along with the search team.
No,
my lord.
that, okay.
Here is a case, my lord, the authorization officer is herself present.
So
at
according to
the
you,
time-
at that stage, no authorization is required.
Yes.
If she herself, the authorizing
She-
authority herself is there.
Herself is there. So, my lord, whether it is written or not, even it is there, my lord, that is a written authorization are issued.
Mm.
And she also given in her PW that,
Mm.
yes, it is issued.
Mm.
But when she testifies it, and also, my lord, he given also a part of the seizure team, my lord.
Mm.
So that is, Lordship may kindly note down, my lord.
So according to you, to summarize your argument,
Lord.
that when the person who is competent to give an authorization, he is himself or herself is a part of the seizure team.
Yes, my lord.
Therefore, as she has herself has done the operation or
Operation.
done the
Yes, yes.
seizure,
Seizure.
therefore no authorization is required.
Yes, but the even assuming that, my lord,
Even she has deposed that she has given authority.
authorization.
So
and
where is
also-
that authorization?
And also, my lord, in
Or
the,
do you want to say that there is no requirement of any
And-
written authorization,
Yes.
rather verbal authorization will be done?
yes, because she was present, my lord, she is present. And also, you'll also
Show us
find from
something
the
on that.
FIR, my lord, FIR, my lord, P8, PW.
Now let us see the provision first regarding authorization.
Section 42. my lord.
Yes.
And
What it says.
Any officer of the Department of Central Excise Narcotics such or any other department of central government, including paramilitary force and armed forces, as he empowered in his behalf by general or special order, or any such officer of the revenue, drugs control, excise, any other department of a state government, and is empowered in his behalf by general or special order of the state government, if he has reason to believe from personal knowledge or information given by a person taken down in writing any narcotic drug or psychotropic substance or controlled substance, in respect of which an offense punishable under this act has been committed or not committed, or any document, article which may furnish evidence of commission of such offense, any illegally acquired property of any document or other article which may furnish evidence of holding an illegally acquired property which is liable for seizure or freezing or forfeiture of such and such act, is kept or concealed in a building may between sunrise and sunset, madam. This is between sunrise and sunset, madam. And your lordship will find our provision is here, madam, because it is after sunrise, after sunset.
Understand?
Yes.
But is
sorry.
it necessarily mean
And-
that since it is after sunshine,
After
you
sunset. madam.
need not record that it is after sunshine, therefore I do not require this. Anything, there must be some, this is a, because
Yes.
all, you'll have to lay the only foundational
Yes,
allegation, foundational fact, you have to
Yes.
lay.
Yes.
Then everything shifts upon presumption is against them.
yes,
So therefore it's very important.
yes.
Your believing or not believing will not be important.
No, no. Provided if such officer has.
Where is
written-
that reason to believe? That
Well,
is Mr. Bora is asking. We are also asking. Where is that reason to believe?
well,
Anyway, yes.
Such officer has reason to believe that search warrant or authorization cannot be obtained without affording opportunity of concealment of evidence. He may enter into search. But this is, well, search warrant cannot be obtained. This is proviso part, my lord.
Hmm.
My lordship will kindly see the language, my lord.
Hmm.
If such officer has reason to believe that a
Hmm.
search or warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, he may enter and search such building,
Hmm.
conveyance or enclosed place at any time between sunset and sunrise,
Hmm.
after recording the grounds of his belief.
Hmm.
But this is, my lord, that without authorization, he can, if we go by this section, but here, my lord, he has already informed, my lord.
So you have two, either
Yes.
where is your authorization,
Yes.
or if no authorization,
Yes.
where is the reasons, reasonable belief and reasons recorded, isn't
Well,
it?
he has, yes, my lord, because my
That
lord,
is
he.
so as that will now
sunset,
discard
then
that
he-
provision.
Yes, therefore, my lord, he has already, my lord, informed his superior, my lord, and superior also joined the team.
No,
and-
don't
and-
tell a story.
Yes,
So as
But
the
that is-
material.
that is what I am saying, my lord.
Yes.
Thereafter, the FIR has, after the search, the FIR has been filed, where it is clearly stated that a written authorization was issued to me. So we cannot now disbelieve what is written. And also, my lord, why I am
Where
saying
is the written, where is the written authorization?
written
That document, exhibit?
authorization is there.
Exhibit?
Yeah, exhibit, my lord, is not exhibit, my lord.
Then
It is
forget
there in the
about that.
record.
If something is not exhibited, this
Then
is, this
after-
is,
because
will
when-
not say more.
Yes,
This
ma'am.
paper can be used for something else, not for
And because
determine.
of the fact that, my lord, C is examined, my lord, the authorized
You
officer. has been
understand,
examined.
your argument
Because
is that
We
there
cannot,
was authorization, written authorization, but since that has not been exhibited, since she herself is there,
Yes,
therefore that
yes.
is not
So
required.
why should we, my lord, disbelieve?
Then she, since she has according to you authorized,
Yes.
she is not the also she has delegated her authority to do something.
Yeah.
Now who will do this seizure? She or the other person?
C is authorized for the seizure, my
So
lord.
this was provision from the act
Seizure.
that when even after authorization, if C is present, it is not required, nothing is required.
My lord, contrary is also, my lord, not there because, my lord, if authorization is, my lord, given, my lord,
Argue
whether,
on substance,
Yes,
not,
madam.
don't argue always.
that is, now,
Argue
my
on
lord,
substance.
yes, but that part I am leaving, my lord.
Yes,
Yes, I'm going forward, my lord.
Mm.
I'll come to it.
okay.
Authorization, my lord, issued to me Nahid and such officer, he is entered by, who is empowered by Government of Assam, by notification such and such. On the same day, 11, my lord, these are the, my lord, this part is, my lord, the search and seizure, my lord, and who are the present, my lord. Now, after PW1, my lord, thereafter, my lord, I am going to the evidence part. my lord.
Yes, evidence. It is important.
Noted.
So just give me a situation when there is a no authorized, there is a search and seizure. What will be the effect on the trial? We'll go to the other evidence later on. If there is violation of 42, then should we proceed further in the case?
Whether
First, let
that
us suppose if we are suppose we are satisfied that there is no violation of 42, then
Yes.
we'll go to the other argument.
yes,
Now, till now, we are not convinced that there is no violation. According to us, there is a violation. If the violation is there, then according to you, suppose assuming as a public prosecutor,
no,
you say tell us the principle of law when there is an established violation of 42, whether it will be fatal to the whole prosecution case.
the authorization, whether exhibited.
Assuming, we are saying that forget about this case, that there is a violation of 42.
Yeah.
Then
My lord, 42 violation will, my lord, my lord, there is a, my lord, scope of, my lord, interpretation and substantial
no,
or.
assuming there is
no,
a violation,
Yes.
there is a violation, then what will happen?
And
everything will go.
If it is violation, then it is
Everything
different.
will go.
No,
So
different.
let us first satisfy on violation, will not further. Why should you waste time?
But that is not the only, my lord, case, my lord.
No,
Other-
if suppose they are taken 4 points, one is
Hmm.
violation of 42, doubtful recovery, these, that,
Hmm.
what not. Suppose 42, we have found that yes, there is absolute violation of 42.
Yes.
Then matter ends there. If
No.
matter, if you subject to what you say, if you
No.
say that no matter will not end there,
No.
that is a curable defect. You support us, you give us the law, then if we are satisfied, we will go further. If not, then why should you waste time? At 2. Yes, Chaudhary, you give a short bullet points of Mr. Bora's argument. And you also prepare, we'll complete the hearing today and deliver the order on 24th.
No.
Because next week I might be in a division bench, so may not be possible. And what about others? How much time will you require?
I go by the evidence by at least 1 hour. it will be
1
good.
hour. So if you start at 2, it will be around 3.
Achieved.
And who are thereafter in the queue?
Is also a Aadhaar. This relates to that drugs and cosmetics, whether it will be tribal, Mr. NJ Doctor. Along with this matter, one cosmetic matter was supposed to be listed, but it has been listed today before court number. No,
My lord, that is not part heard, my lord. This
there
one
is
is
no
part,
Aadhaar.
only the point to be determined, my lord, whether it is a narcotic. What is narcotic drugs?
Okay.
If I satisfy your lordship, 15 minutes, my lord. I have no objection.
At some other day.
Well, I have no
24, 25th, we'll take it up that. And Mr. Chaudhary, because 3:45, I'm in having some interviews.
7,
So
8, 9,
otherwise I will rise at 3:30.
7, 8 and 9.
Ah.
Analogous matter. Mr. Bora is also there.
Bora is also there.
Bora is courier है, yes.
Bora would like to go home now.
No, not before 3:30.
Generally goes, my lord.
That's right.
In that case, my lord, my matter, my lord, item 5 on
It is-
25th.
Yes, sir.
Eh?
It will be as a text,
25th.
25th, subject to my lord. What's it say?
25th. NJ Dotto, 25th.
Item 5.
And Mr. Bora and
789, ma'am.
789. When?
Total of it,
Further lordship had already heard, so
Uh,
short date.
sorted. Before
Any day,
vacation, we will
any day.
finish that all before vacation.
Assam
No more
total
further
of
part
it,
hearts. These are the,
2009.
huh? Okay, no more
That day,
fresh,
already
fresh part
lordship
hearts.
had noted down our
Ha, ha.
PW is already
Ha, ha,
completed.
ha. That we have already PW part we have dictated. I think if it is completed, we are thinking of giving a circulating a copy to you. Question or not. But I have not corrected as yet. So
Lordship also asked to give a note, so I have prepared.
yes, we'll take it matter again on 25th.
Wow. So
25
what-
possibly last week is a motion week, so
What motion? Motion will finish by 12.
12 o'clock.
Motion will finish by 12.
Oh,
Is that it, Mr. Rattan?
Hmm?
Okay, at 2, we will complete this matter today and we'll note it down and you give a note just so that we can record your argument in your words. And thereafter we'll deliver it on 24th.
Processor.
Yes, Mr. Chaudhary. 25th?
Also processor pabo.
We'll give a try. All pending matter.
Regarding the first part, because
Uh,
first part is for most my lord.
Half
I
part
have
is formal,
almost-
that's why.
That's why I am searching for any authority so that I could place it, my
Uh-huh.
lord, that my lord, for going further, my lord.
Okay.
Without the, that is what I am searching for. I couldn't get it now. That is what I am searching for.
So you want
Because,
some time.
yes, because.
to
that will-
argue?
Yes, my, because if law is there, my lord, I cannot, my lord, escape, my lord.
As far as
Yes. Yes.
my limited knowledge is
Yes.
concerned, law is very firm,
Yes,
very clear on this point.
just,
Because see, the whole act is very stringent.
yes,
So therefore, and the presumption is totally reverse here,
Yes.
not a general law.
yes, yes,
Only you will have to lay your foundation.
yes,
So therefore, in laying the foundation,
yes.
we must be clear. I think in sitting in a division bench, I have passed a judgment so far relating to this
Yes.
fundamental principle.
Because
So-
if law is against me, my lord. I
So
cannot
therefore,
argue, my
these are important things. Why this prescription is that reasonable belief? Why
Yes.
this word has been used?
lord.
Not only here, if you see in PMLA, they are also reasonable belief. Where belief may not be, we may
Yes.
not judicially
Yes.
review that.
Yes.
But that he is having a reasonable satisfaction
Yes.
should be on at least on the record. Reason why he is satisfied may not be necessary, but that he is reason to believe. Reasons we may not have, but
Yes.
there nothing is there in.
I mean,
That's why,
I'm also,
because
my lord,
Mr. Borar whole case is that this is an absolute violation, total non-adherence.
son,
Yes, for total non-adherence from the starting to the
I
recovery.
have seen my several loopholes at there, my lord.
Many loopholes. Not only that,
Yeah.
if we go deeper,
Yes. But,
even those materials are not there.
yes, so my lord, that is, I am also not inclined to, my lord.
The only thing is
Yeah.
that we will give you a chance.
Yes.
That is not an issue, but at the same time, our anxiety is also, suppose we acquit. If we convict, no problem on this.
Yes.
If we acquit, as a judge, it will a problem on us that we have acquitted. Every day's delay is a, so therefore,
Yes,
so in this, suppose we think that it is a case of acquittal, we'll try to dictate in the court itself.
Yes.
So that's why so what do you propose?
and that is what my, if I
No,
get
you
something.
propose, no if but, you propose what you want to do.
For today, my lord.
For today.
Yes.
Okay, no issue, let him have a fair chance.
And
Okay,
to-
you go through it, no problem on
before,
it.
my lord,
On
because
25th then, together, okay?
Okay.
We'll just start working the homework facts and all, we'll just record it and sitting in the chamber. Chaudhuri, if you can give your, yes, okay.
I'm
Hard in
obliged.
part for further hearing, release this matter on
25th.
25th.
But he has argued, my lord. There's a similar situation has happened, and there is a one police officer. He was initially posted in Punjab.
Mm.
Then he was later on, he was shifted to Assam also. KL Meena,
Mm.
he was a DGP here.
Mm.
His case is there when he was in Punjab.
Mm.
He was the gazetted officer authorized.
Okay.
In that case also, the Supreme Court says no. That will not because you have also the duty.
Hmm.
Though you are a searching officer, you have also being an authorized also, you have to intimate your grounds of belief.
Hmm.
On record, because this is in writing. That's very important.
That is important. That is important.
In writing.
That satisfaction is nowhere here. Here simply like other GD entry that I have heard somebody has been murdered
First
somewhere.
part.
I am proceeding to them. That is
Then the authorization comes on.
function.
If there is no authorization, even then again, if there is no
There are
authorization,
even some exception has been given in under what circumstances you can
Yes.
the other part you
Yes.
can for the
Yes.
time being you can
Proviso.
waive and you can correct.
Later
But
part.
one part later part. But
Later
first part is
It would have been better, my lord, if we had taken the course of proviso, my lord.
anyway
but
20
within 72 hours, he has
Yes.
got, but that can be delayed.
that can be delayed.
That this is the ground for delaying that I would not intimated within
But
72
here
hours.
nothing is there.
There is nothing.
Nothing is
That is the mind.
That is the issue. So if it clicks here, we may not go further. That is what
I'll like to go, Lordship, to go further because of the reason is that if tomorrow, if they goes for the appeal,
okay. Okay.
then the other points also important, maybe in some cases.
Okay. So let us go one by one then.
Sir,
We are
am I
giving him
hearing
some
that
time. Let him
correctly?
prepare properly.
Yes.
Come back
immediate.
and you also have your point of note of argument.
Yes.
So that we can, should not be any complaint that we have not recorded the point of argument.
Yes.
That is, I think, important for everybody. At least the point of
Yes,
seeing the point,
yes.
just bullet points that this is your arguments.
Tomorrow I submit it also.
Okay.
25th.
Thank you.